All right, I think we're going to get started here. I want to say hello. Thank you all for joining us today for our MTSU Alumni Lunchtime Learning webinar. I am Rachel Helms. I am one of the assistant directors here at Alumni Relations, and I am very excited about our guest speaker today. Ashley Stearns is going to be going over the fundamentals of estate planning with us. Very quickly, I just want to thank you all of our amazing alumni. You are a vital part of our university community, and all of your involvement and giving makes a huge impact on our students. We're finishing up our recruitment tours this week and next week. So if anyone is interested in volunteering for our Murfreesboro-Williamson County True Blue tours, just let me know. I'm at rachel.helms@mtsu.edu. Now on to the program. Ashley Stearns is a well-known estate planning attorney here in Murfreesboro with the firm Trail, Coleman Stearns. She earned her undergrad here at MTSU in political science with a concentration in pre-law and earned her law degree from Nashville School of Law. She's currently pursuing her LLM at Texas A&M University School of Law. She has chaired the Tennessee Bar Association's Estate Planning and Probate section and has served as president of the Murfreesboro Estate Planning Council. She is very involved in the Murfreesboro community. She serves as a trustee and secretary of Providence Christian Academy's Board of Trustees. She's a board member of United Way of Rutherford and Cannon Counties and a volunteer with the Charity Circle of Murfreesboro. Ashley, welcome.
Rachel, thank you so much. And before we get started, want to thank you and Courtney and Alumni Relations for putting this on. I want to say I had a tremendous experience at MTSU. I would not be where I'm at in my career without my experience at MTSU. I did the legislative internship with John Hood, and that's where I met my law partner, Kent Coleman, Trail Coleman and Stearns. And I have just so many wonderful memories from MTSU and so thankful and grateful to be here today and excited that I get to talk to you all about this very, very important topic. So it's estimated that up to 60% of Americans don't have up-to-date estate planning. For me, that's shocking because this is really just a part of financial wellness. Everyone should have up-to-date estate planning. Regardless of your health, wealth, or age, you need up-to-date estate planning. It's estimated that over the next 2 decades, $84 trillion is going to pass to the next generation. So that just highlights how important and how crucial it is to have this in place. What I'm going to do today, obviously, when you talk about estate planning, I get lots of questions. So I wanted to try to get through 5 points. And then after those points, I wanted you guys to just hop in and ask questions. So if I can get through my 5 points, and then we'll start doing questions. So my point number 1, most important, is outline your wishes. So what exactly does that mean? If you don't remember anything else that I've said today, I want you to remember this one point. You need an up-to-date power of attorney. So if you don't have a power of attorney in place, do you know what happens? You have to go to court to make decisions for the person who's incapacitated. And that could be a $5,000 process. So you would have to petition the court for a conservatorship, and then a guardian ad litem would have to be appointed to do an impartial investigation. So like I said, if you hear nothing else today, make sure you and all your loved ones have up-to-date power of attorneys. That document is very crucial, and it's an easy document. And most of the time when you're doing your estate planning with an attorney, that's just part of the package that you will do. You usually will do a durable power of attorney, which means it survives your incapacity. It's effective immediately. You also could do a springing power of attorney, which is only effective upon your incapacity, but you can talk to your attorney about which one might be best for you. So part of point number 1 is outline your wishes, make sure you have that power of attorney in place. So that's a power of attorney for financial decisions. You also need a power of attorney for medical decisions, and that would be where you appoint someone to make medical decisions if you can't. Also, the core of any estate plan would be your will or revocable trust. That's where you can outline what happens if something happens to you, to your assets that are controlled by your estate plan. Now, I like to highlight what happens if you don't have an up-to-date estate plan. So what happens if you don't have a will? What happens if you don't have a revocable trust? So if you pass away in Tennessee without a will, most people think that all your assets are going to go to your spouse. Well, if they're in your name only, that's actually not the case.
Yes, sir.
So if you do not have a will in place and you have assets in your name only and you have children, your spouse will get some of your assets and the children will. Also, if you have a blended family, it's even more important that you put down what your wishes are, because chances are, if you pass away and you have stepchildren, they would obviously not be included in who gets your estate when you pass away. So that's number one, kind of an easy point, but just outline your wishes, make sure you have these documents in place. So point number two, understand what the tax laws are. I'm going to go over those real briefly, but in the not so distant past, for example, in the year 2000, many people were driven to do estate planning because of the estate tax exemption. It was only $675,000 in the year 2000. So obviously we've come a long way since then, and not everyone is doing estate planning just because of the tax laws. Right now, we do not have an inheritance tax in Tennessee. That went away in 2015, but the federal estate tax exemption this year is 13.99 million, and that is per individual. And that's something that collectively you've got 27.98 million that you can pass tax-free to your heirs.
Good.
Next year, it will be 15 million per person. So not as many people have taxable estates, but it is important when you're thinking about estate planning to understand what the tax laws are. So right now, no inheritance tax in Tennessee, and then the federal estate tax exemption will be 15 million next year per person. You also can do 19,000 per year if you want to gift to your family members without filing a gift tax return. That's something that's important to understand and have on your radar when you're thinking about your estate planning and how you're gifting to your family. So that leads into point number three. So point number one, outline your wishes, make sure you have these documents in place. Point number two, we just went over a little bit of what the tax laws are. Now, point number three, this is a really important point that you can start on today. So keep your beneficiaries up to date. This is an item that is often overlooked. I'll have someone come into my office, someone has passed away, and they'll have a former spouse as a beneficiary. And unfortunately, if that former spouse is listed on your life insurance, they're going to get that life insurance policy. There's nothing your estate can do about that. So when you're doing planning and you're working with an attorney, I normally have my clients fill out an intake form. And that intake form is very important because if you write a will, I can write a will leaving everything to Rachel. But if my beneficiaries go to my, they are designated to Courtney, then Courtney's going to get the assets. So it's very important when you're doing your estate planning that you understand what actually is going to pass through the will, what actually is titled in the trust, and then what is controlled by beneficiary designation. Like I said on the intro to this point, this is something you can go ahead and start looking at today. If you already have planning in place or you don't have planning in place, this is something that you need to double check annually. So that would be, who are the beneficiaries on your retirement plan? So who normally you list your spouse, and then who is the contingent beneficiaries? It normally, after the Secure Act, there are certain EDBs, eligible designated beneficiaries, meaning there are certain classes of beneficiaries that can have a longer payout, but most beneficiaries will just get a 10-year payout. So it's important to be mindful that you list beneficiaries, because if you don't have beneficiaries, usually your estate is subject to a 5-year payout. So it's very important that you have your beneficiaries up to date on retirement plans. Also, like I already mentioned, life insurance, you want your life insurance to pass consistent with what your planning wishes are. So maybe that's your spouse first, then we're going to talk next about trust. So you might name a trust as the beneficiary, but make sure, or if you have adult children, you might be fine just listing the adult children, but make sure your beneficiaries on your life insurance are consistent with what you want your planning goals to be. Bank accounts. This is something that I see routinely that does not match the estate plan. I have a lot of clients who will want to put a child on the bank account, and they might not realize, well, if you put a child on the bank account, what if the child gets divorced? What if the child gets sued? What if the child passes away? So depending on how your account is titled would depend how that account passes. So be very careful when you're adding someone to an account. Normally, if it's husband and wife, you might want to make it joint. You can also, put a payable on death beneficiary, but you just need to be mindful and careful who you're adding to your bank accounts because it might not be consistent with your planning. You might not want it to just pass to that one child. That's why the power of attorney is important. So if your child needs to help you with your bank account, they can with the power of attorney, but they don't have to actually be an owner of the account. So that's something that's just very important to be mindful of how you're doing those bank accounts, brokerage accounts, any type of asset that you can name a beneficiary on. You don't want to name minors either. So if you name a minor as a beneficiary on an account, they're going to have to set up a guardianship most likely. That's why trust planning is really important for minors. And I'm going to get into that in the next section. My last point on the keeping the beneficiaries up to date. Tennessee does not have a transfer on death deed. There are lots of other states that have these type of deeds. So if you own real estate in other states, you want to be mindful of how you're able to create these deeds. I do not advise clients to do life estate deeds. You want to be very careful whenever you're doing lifetime transfers of property, because if you put someone on a deed as a survivorship deed or a life estate deed, you can't change that. You can't change that without them, maybe gifting back. So you can put property in a trust for someone's benefit. So be mindful before you just prepare a deed giving property away. Be careful and be mindful of your decisions there, because when you do put someone on a deed like that, it is irrevocable. And like I said, Tennessee does not have a transfer on death deed, but we do, I do see attorneys that are helping clients and they might do a survivorship deed, or they might do a deed that creates a life estate. And I'd just be careful, because I prefer to do trust planning, because those deeds, are irrevocable. You can't change them. And then it might not be consistent with your wishes later on. So point number 3 is just keep your beneficiaries up to date. I recommend that my clients put together a binder and keep that binder updated with what are all your bank accounts that you currently have, who are the beneficiaries, have a copy of your last year's tax return, and keep that with your estate planning documents so that your executor can get to that and have easy access to it. And then every year exactly how those accounts are titled, exactly how those assets are going to pass. So, okay, point number 4, we're going to spend a lot more time in this section because it's very important and it has tentacles in all different areas. Marital trust, revocable trust, trust for minors, lifetime trust for children, Tennessee Community Property Trust, Tennessee Investment Services Trust, Special Needs Trust. This point 4, I'm going to talk about a lot of different variety of trust, because that is such an important part of estate planning and something that most clients are going to utilize a trust for some reason. So I'm going to try to spend the next chunk of our time talking about different types of trust and different types of planning opportunities. So first off, our firm, every client does not need a trust, right? Not every person needs a revocable trust. The reason why you probably have heard you have to avoid probate or you have to have a revocable trust is because if you live in Florida, if you live in California, if you're from Illinois, those states, you absolutely have to have a trust, and you really need to avoid probate if you live in those states because it's costly, it's time consuming. Tennessee, we're just very fortunate that we have a very friendly probate process. I've probated in most of the counties in the state, and they are all, friendly, easy access. You can get in. In Tennessee, you just don't have to avoid probate. You will get some attorneys that, tell you need to avoid probate. What I do with my clients is I do an assessment with them. Do you own out-of-state property? Do you have privacy concerns? Have you seen trust? Do you want to avoid probate? Because yes, we absolutely could do that, but there are some advantages to going through probate if you want to sell real estate. So my first item in the trust planning bucket would be, at the onset, do you need a revocable trust or do you just need a will? So not everyone needs a revocable trust. Some clients don't want to retitle their home. They don't want to redo their insurance. They don't want to move all their accounts to a trust, which is totally fine. So you can do a plan where you don't utilize a revocable trust. But if you own out-of-state property, you're going to want to do a revocable trust because you don't want to have to probate in multiple jurisdictions. So if you did have a house in Florida or you have a house in New York, most of the time you're going to set up a trust and you're going to put it in the trust, and it just makes things a lot easier, and you could retitle your assets in the trust as well. But I get a lot of questions about what's the difference between a revocable trust or an irrevocable trust. When you're talking about a will substitute in your normal trust planning, most people do use a revocable trust for planning purposes and to just streamline if they did want to avoid probate, if they do have privacy concerns, that's when you would utilize the revocable trust. Now, the trust I'm going to talk about next is a trust for minors. So regardless if you need a revocable trust or not, if you have minor children, you absolutely need a trust. I have a lot of clients who don't want to retitle their assets in a trust while they're alive, so they will do a trust under will for the children, which means the trust only creates at the second death. If you and your spouse both pass away, they create a trust for their children. Now, I get a lot of questions. Why can't I just give it to my sister? My sister will take care of my kids. I don't want to set up a trust. That seems like a lot of trouble. Well, what if your sister dies? What if your sister gets divorced? What if your sister gets sued? Then your child's inheritance is gone. So you absolutely need a trust. I cannot tell you how excited I get when I have couples come in and do planning for their minor children, because it is one of the most important things that you can do for your children. And I would, to be honest with you, most of my clients are, over 60. I have lots of young clients as well, but the people I'm seeing every day, day in and day out, are usually, I've retired, I want to finish up my planning, or I'm going on a big trip, I need to do my planning. It's really, really important if you have minor children that you have your planning in place, because it would be really catastrophic if something happened to you untimely and you don't have planning in place. What happens is the court has control of your assets. So until the children are 18, you're doing a guardianship. You have to do annual accountings to the court. You have to pay for a bond. You have to pay attorneys. And then you don't get to pick who even are the guardian of your children. So planning is so important if you have minor children, that you can pick who the guardian is. You get to pick who the trustee is. You get to pick at what age they get it. If you don't have a trust for your minor children, they're going to get it at age 18. And, we all know at 18, it's not good to get your assets that early. It would just be, not good for the child, not good for anyone involved. So you want to do planning where the children, you can set ages that they receive them. I have a lot of my clients have been setting up lifetime trusts for their children. The reason they do that is because one of the easiest ways to provide creditor protection for your children is when you set up a trust for them. So if you leave their inheritance in trust, they are going to be afforded greater protection, meaning if they get divorced, if they get sued, if the trust is treated with the integrity that it deserves, it's going to be, they're going to be afforded those protections. But you're going to have to think about who's over the money. At some age, are you okay with your child being over the money? I have clients who will set up the trust for their minors, ending at 25, ending at 30. Then I also have clients who set up lifetime trust, and then they will have the child become their own trustee at 25, become their own trustee at 30. So you have a lot of different options and a lot of different varieties of how you can set these trusts up. I normally recommend that when you do have minor children, you just hold it as one trust until they reach a certain age. When they reach a certain age, then it can divide into separate shares. So you could allow it to divide into separate shares, maybe when they're 21, maybe when they're 25. This just allows your children to have control over it at different ages, but then also not be dipping out of the same pot, meaning, if you have it divided into separate shares when they're 21, then basically you've gotten all of the kids through college, and then it divides into separate shares. So there's lots of different ways you can set up trust for minors, but that is a really, really important point. And if you have minor children, it's important that you have your planning in place. And like I mentioned, in having up-to-date beneficiaries, you don't want minor children as beneficiaries of financial accounts or insurance, because then you would still have to set up that guardianship. So that's why you want to create these trusts for the minor children to protect the minor children and make a seamless estate plan for them if something were to happen untimely. I always say that estate planning is one of the best gifts you can give your family. And I got a question here. Let's see. Do you know how I get to the questions? Were they here? Q&A. Is it over here?
Got it.
What is it, Rachel? Do you want to read it?
Sure. Let's see here. If multiple siblings inherit a property, what is the best way to protect the property from situations that could occur to one sibling, such as a lawsuit or debt? Repeat it.
So basically, multiple siblings have inherited a piece of property. I have lots of clients who go ahead and, they will set up a trust for their children and they will put the property in trust. So setting up a trust would be one of the ways to protect the children. And, it's really pretty seamless for these trusts to own the property. So to answer your question, probably to utilize the trust in the estate planning would be a great way. Tiffany has asked, my son, only child. Rachel, if you'll read that again, because the questions pop up and then they disappear. So,
of course, my son, an only child, just turned 18. Am I able to still set up a lifetime trust?
Tiffany, that is a great question. Absolutely. You can do anything that you want. You can leave it in trust till he's 45. You can leave it in trust for his lifetime. Absolutely. I think that 18, you would not want an 18-year-old to get their inheritance. So you can set up a trust for them. I think the other question that just popped up was, can you do a lifetime trust for children, grandchildren? Yes, you can set up a lifetime trust for anyone, really. You would just need to think about who is going to be the beneficiary of the trust, and then who is going to be the trustee over the trust. But I've been talking about minor children. I'm actually going to get into other trust scenarios, but any irresponsible beneficiary or just anybody that you're wanting to protect. Like I mentioned, I'm going to talk about another trust that was created by the legislature that is a self-settled asset protection trust in a moment, but it's really hard to create a trust that's protected. But when you create it for someone else, that's one of the easiest, cleanest ways to create protection for someone. I have a lot of adult children that are dragging their parents in for estate planning because they want a trust that's protected. They want to have their inheritance protected. So they will, have their parents come in to set up trust for their inheritance. So that's one of the easiest ways to get creditor protection for your beneficiaries. So Tiffany, to answer your question, yes, you can design a trust for your child that's to any age or for his lifetime. You also can give your beneficiaries powers of appointment where they can say where the trust goes at their death. So even though you're creating a trust and putting restrictions on them, you can still allow them to have say over where it goes at their death. Or if you didn't want them to have say over where it goes at their death, you can do that too. So there's a lot of flexibility to how you create these trusts. Tennessee is ranked third in the whole United States for having some of the best trust law. I always like to talk about Kent Coleman, my former law partner. He was actually judiciary chairman when Tennessee brought in some really important changes to the Uniform Trust Code. For example, the self-settled asset protection trust that I mentioned. Now that trust is, yes, there are 17 states that have these asset protection trusts, but there's a lot of hoops you have to jump through, and it is self-settled. I don't know that it's ever been tried before the Supreme Court. So it is created by the legislature. So, you don't know, is it 100%, is it going to work? But, they're being utilized. It is created by the legislature. I just hope I've explained the distinction easy enough that when you create a trust for someone else, that is a lot cleaner and easier way to get creditor protection than when you create a trust for yourself. It's a lot harder when you create a trust for yourself to achieve those type of protections. So moving on, I've talked a lot about children and designing these lifetime trusts. I wanted to talk about a marital trust as well. So a trust, I'd say probably about 50-50 of my married couples, especially couples in a second marriage, they choose to utilize what's called a marital trust. A marital trust is a trust that you can create for your surviving spouse, and you basically are allowing them to have use of the assets during their lifetime, but you control where it goes at their death. The reason the marital trust is so important is because I'm sure everyone has seen a scenario where there's a second marriage, the first marriage kids get disinherited, they're not protected, or mom and dad gets taken advantage of, marries someone 20, 30 years younger, and then first marriage kids are not getting their inheritance. That's why it's so important, even if you're in a stable long-term marriage, to think about maybe setting up a marital trust at the first death. Because I always say it's how much risk do you want to mitigate? You don't have to set up a marital trust. You can leave everything outright to your spouse, but you should at least contemplate, do I want to protect any of my estate? So if something happened to me, I know the children have received a certain portion of the inheritance. I like to suggest to clients that this is not an all or none proposition. You don't have to put everything in the marital trust. You can put just certain items in the marital trust. And, if you protect half of your estate, maybe you're comfortable and happy with what you've achieved. You don't have to put everything in there, but it is something to think about. So, also, if you have any beneficiaries who have special needs, you'll want to do a special needs trust. That's very important. You don't want to leave anyone who might qualify for public benefits assets. You don't want to disqualify them for what they're entitled to receive. So you might want to set up a special needs trust for them. That planning is very important. If that you have someone in your life that you love that has special needs, you need to make sure that that's part of your planning, whether it be a child or grandchild. You'll need to have considerations for that. There also is another type of trust in Tennessee called a Tennessee Community Property Trust. We have lots of clients moving here from lots of different states, and some clients will move here from a state that has community property. Tennessee is not a community property state, but we do have this trust option where you can create a trust. That's called a Tennessee Community Property Trust. And if you are in a long-term stable marriage and you have a farm, maybe have low basis assets, it's a really good option for appreciated property, because what can happen is you can get a full step up at the first death, and you can also start over on depreciation, maybe if you had rentals. So that community property trust is just another type of trust that we have in our toolbox, that if you come in and you have, property like out of state property or appreciated property, maybe you would consider using this type of trust for your family. So I always just like to mention that, because I see those used a lot. They're a very popular planning device, and I'm starting to have more financial advisors that have accounts that are really low basis accounts. They might mention it to their clients and say, hey, you might want to think about this, because really, if one of the spouses pass away and you were to sell any of that property, it can be very beneficial from a tax perspective. So I always say mention that to your CPA as well. That's just another type of trust in the trust toolbox. So I've highlighted a lot of these different types of trust, and now that I'm getting through my points, I usually can't get through my points if I take questions at the beginning, and I just get bombarded with questions and I get completely off track. So I've made it at least 30 minutes through, and I've got out a lot of important points. So you are welcome to continue asking questions and ask questions at any point. I am going to keep talking, but I did want to let you know, at this point, I feel like I've gotten enough out that you've heard some very important points, like make sure you have a power of attorney, make sure you plan for minors, talked about the different types of trust. I've gotten enough out in the first 30 minutes that hopefully, if you have listened so far, you've gotten some good points. And Rachel, can you read me that question? I don't know how I make the questions stay up.
Sure. This one is, what states do you work in? Is it just Tennessee?
I personally am only licensed in Tennessee, but I have a tremendous network of attorneys that I use. If I am transferring out of state property to a trust, I will call on one of my colleagues to prepare the deed, or if I have, just any need. I've got a great network that I utilize for referrals in other states, but I am only licensed in Tennessee. I only practice in Tennessee. Obviously, clients have property all over the place. We will create trust that holds property, in multiple states, but if you live or you're domiciled in another state, if you move out of Tennessee, I always recommend that my clients get another attorney. If you ever move Tennessee, you change your residence, you really need to have your estate planning done in the state that you are, that you're going to live in when you think that you will stay in until you pass away. You really need to have your estate planning done there.
Well, here's a question from Kimberly. How does a partnership work when it comes to multiple family members owning property?
That's a great question, Kimberly, and I'd have to look at the partnership agreement to be able to answer that. So my best advice would be get your hands on the partnership agreement and then provide that to your attorney to look at, because you're right, that can get really complicated. And it looks like we've got a lot of questions rolling in. I wish I could see them somehow. So Rachel, you didn't have to. Oh, I can see them here, Rachel. Okay, I figured out. I can see the question.
Perfect.
Okay, next question is, how do I know which trust is best for my child, irrevocable or revocable? How will the trust work along with life insurance? That's a great question. So one important distinction here, when you create a trust for someone else, that's irrevocable. So you're not deciding between revocable or irrevocable. When you create it for someone else, that trust is irrevocable. So yes, that trust for your children, even if it does not fund until you pass away, even if you fund it under your will, that's an irrevocable trust. And you absolutely can put your life insurance in that trust. Most people with minors do. And, if you think about the equity in your house, your life insurance, your bank accounts, when you have minor children, that stuff adds up. One thing I like to say whenever I'm speaking to groups about estate planning is insurance is one of the most non-legal ways for you to effectively help protect your family. Make sure you have umbrella insurance in place. Make sure you have life insurance. You're not getting any younger. Even a term policy until the kids are grown is a great idea. So always make sure that you are sufficient in the life insurance category. That's something I always talk to my clients about. If you were wondering what point number 5 was, because I hadn't got to that yet, to round out the 5 points, point 5 is assemble a team. You absolutely need to have an estate planning attorney, a CPA, your life insurance professional, and your financial advisor. I think on my intake forms, I ask my clients, who does your insurance? Who is your financial advisor? Who is your CPA? Do I have permission to talk to them? I think effective estate planning is not just a will. It is absolutely a cohesive plan with all of these professionals working together and being mindful of each different section. Okay, next question. My nephew has inherited his mom's home recently. He is mentally disabled with no children. Do you have any advice on how we would handle his estate? So that's a great question. It sounds like you would have to set up, if he's an adult, it sounds like he's going to need a conservatorship. So if he is mentally disabled and he's received property and he can't manage it himself, it sounds like you would need a conservatorship in that case. So what you would do is you'd hire an attorney, they'd petition the court for a conservatorship, you'd get a doctor's affidavit stating that he doesn't have capacity, and then someone would be appointed conservatorship over his property. Now, it depends to what degree you said he's mentally disabled. If a doctor says he has the legal capacity to make decisions, maybe you do a power of attorney, but really you're going to need a determination from a doctor if he could make legal decisions. Most likely it sounds like he might need a conservatorship. Okay, next question we have in the chat is it better for the power of attorney or guardianship attorney? I'm in Georgia. Any trust attorney you would recommend? Jasper, if you'll send me an email, I have a certain site. It's called AgTech. I usually go there to get referral sources, but I'm actually taking part of a fellowship program, and there are some attorneys from Georgia. So if you'll shoot me an email, I can send you some Georgia attorneys to for whatever you're needing for a guardianship or for power of attorney. I can get that over to you. Okay, those are great questions. Keep the questions rolling in. I will still talk more about how trusts work because that's one part of estate planning. I feel like when clients come in, they don't know what they need and they have lots of questions regarding how the trust works. So when you're doing your planning, I have clients fill out an intake form, like I mentioned, and on the intake form, I have them list how their property is titled because you're going to want to look at the deed to determine, is it titled husband and wife? Is it in one name only? Then you'll list all of the bank accounts. You'll list if you have out of state property, and then you will also list all of your retirement accounts. And basically, it's going to be a comprehensive financial statement. So normally what the estate planning process looks like is you fill out your intake form, then you sit down with an estate planning attorney. During that first 1 hour meeting, that is going to be one of the most important meetings that you will have because you're setting the stage for how you want this to look. What are your concerns? Questions I ask, things you'll need to consider when you're working with your estate planning attorney. Do you have any genetic material out there that you need to plan for? Have you ever lived in a community property state? Did you sign a prenup? If you did sign a prenup, we need to see a copy of the prenup. Also, are you or your spouse veterans? Do you have any, are you divorced? Is there a divorce decree? So you cannot imagine how detailed and comprehensive estate planning can be. You think that it's just you do a will and you're done. Well, there are so many nuanced things that can affect the disposition and the outcome of your estate. So that's why you need to have all of these items together when you meet with your estate planning attorney, because the estate planning attorney needs to know, have you signed a prenup? Do you have any obligations post-divorce to a spouse or to your children? These are all things that could ultimately affect the disposition of your estate planning. So they're very important that you disclose those things to your attorney that you're working with. Tiffany said, this may not be in your purview. However, now that my son turned 18, does he need to have any of these? Obviously, he has no estate, but any areas of your expertise? Tiffany, absolutely great point. Remember, I said, if you hear nothing else I've said today, make sure everyone you know and love has a power of attorney. That includes your son who has just turned 18. If you have any adult in your life needs a power of attorney, including any children turning 18. I could tell you unfortunate stories where kids have been off at college, they have some sort of medical or mental emergency, and mom or dad don't have a power of attorney. They go to the hospital out of state, and the hospital initially, may or may not talk to them because they don't have a power of attorney, and the child is an adult. So yes, Tiffany, that is an excellent point for everyone on the call. When I say everyone have a power of attorney, that even means your adult children. And that is something you should not let them leave for college until they have that in place, because you don't want to get into a situation where, they're medically fragile and you don't have it. Okay, next question. Do I need to redo these documents once my kids turn 18? No, you don't necessarily need to redo them when they're 18. I like to write plans that withstand the test of time, but if you set up a trust until they're 18 or you set up a trust until they're 25, it really just depends how you wrote your plan. Do you want it to be a trust that extends beyond 18, or how did you write it? So if you had changes in who you want to be executor is the person who takes it from when you pass away to administering the estate, and then the trustee would be the person who's over the money until they reach whatever age you've prescribed. Then next question, if two people own a house and one person puts their half in a trust, what happens to the other half of the house when the owner without a trust passes? Are there resources for low-income elderly? Well, let me take this one part at a time. So the first question is, what if you own a house tenant in common? Then one half is in a trust. You can only control your half, and if you put your half in a trust, that's fine. If someone's half is not in a trust, then normally their will would control if they have a will. If they don't have a will, then Tennessee and intestate laws would control who gets it, and it would be subject to the probate process. So that's the first part of your question. And then the second part is, are there resources for low-income elderly individuals who want to create a trust but cannot afford the quoted amount to set up a trust? You know, there's legal aid, but I don't know if legal aid assists with estate planning. Here's the thing, though. You may or not, like I said in the early part of my presentation, not everyone needs a trust. So it may be sufficient that a will covers what they need. You know, you just have to look at each person's individual situation to determine if they even need a trust. Tiffany asked, durable or general and for healthcare only. So you can talk to the attorney. I like to write durable power of attorneys, meaning they're effective immediately, because if you write it where it's springing and it's not effective immediately, then you've got to prove incapacity for the power of attorney to work. Now, if you're afraid your kids are going to steal all your money, then you want it to be springing, right? You don't want to let them steal all your money. You only want it effective when you're incapacitated. However, you can have that conversation based on your unique situation. Do you need it to be durable or do you need it to be springing? And then, yes, absolutely, you want a healthcare one as well. So I recommend doing financial and healthcare, because usually, even if they're in college, they'll have bank accounts, or if you're dealing with insurance, that can all be financial. Okay, you asked, can you create a power of attorney that doesn't go into effect until the child is 18? Really, the child that's turning 18, they're the one signing the power of attorney, so they need to do it when they're an adult. So I would just recommend as soon as they turn 18, they've got to be an adult. So just as soon as they turn 18, you'd want to get those documents in place. Okay. Then Beth has asked, can you back up and explain the difference between a will and a trust? Yes, that is a great question. I spend a lot of time with clients talking about that. There are types of trust that really are just a will substitute. So a will affects the disposition of your assets at death. I always like to illustrate for clients when I'm in my initial meeting with them that assets pass one of two ways. They either pass by contract or they pass by operation of law. If they pass by contract, they're going to pass automatically. Beneficiary designation, if the deed's husband and wife, that means that supersedes the will. So regardless of what your will or your will substitute says, if they pass by contract, it doesn't matter what your will says, they pass automatically. Now, if they pass by operation of law, then you're going to have them, that will pass through your will, or if you have it titled in a trust. So your question as to what's the difference, or, you know, which one do I need? They are just different ways of getting to the finished line a lot of the time, but there are things that trust can do that wills can't. So wills will absolutely effectively, you can put in what you want to happen with your assets that the will controls. However, with the trust, you can, as I've highlighted, I could literally talk to you for an entire week just on trust and trust options. There's so many different trust options. But what you need to remember is your will or your revocable trust, it's really just a way to outline your wishes. So if you don't outline your wishes, you know, Tennessee law says what's going to happen. But your estate plan, you have to think of it more broadly than just a will. Your estate plan is going to be, how do your assets pass automatically, by contract, by beneficiary designation, and then what does your will trust control, and how does that pass? What I do, and what other estate planning attorneys I'm sure do, is I want you to understand how everything passes. That's how you create an effective estate plan, is you utilize these tools, you utilize your trust toolbox, you utilize the will to make sure everything cohesively passes and gets to where it needs to go. Because if you mess up a beneficiary designation, then that account is not going to get where you want it to. So I know that that's a long answer to talk about the difference between a will and a trust, but essentially they can do some of the same things, but there's lots of different types of trust. And essentially there are both ways that you can outline your wishes and protect your family to make sure that your estate plan is carried out effectively for the ones that you love. Okay, we've got more questions over here. Are you able to take me on? Well, Tiffany, yeah, just email me offline. I'd be honored to, and we certainly can talk about what your 18-year-old needs. So thank you. That's so kind. And then next question, Matt, you mentioned the community property trust step up in tax basis. Besides that, what other trust do you see most commonly used for tax related purposes in Tennessee? Interesting question. So like I mentioned in the intro, not as many clients are coming in because they're worried about tax laws, especially estate tax. Now you're trying to control mostly income tax because that's the tax that everybody has, right? So not as many people are concerned about estate tax when they come in, but there are different types of vehicles like the community property trust where you can maximize basis at the first death. That's a great example. And let's keep going. What about property in an LLC with husband and wife as members? What about that? So that's a good question. Yes, so you do have clients that are utilizing LLCs for lots of different reasons because yes, you want, that additional layer of protection, kind of like a trust that can provide you some creditor protection. The LLC does that, especially if it's a business. Now, Jay, we've got one. I'm going to try to get through these questions. We've got 13 minutes left. If you create a trust, are you responsible, the client, for maintaining documents, or is there a central location that would prevent someone from altering the physical copy? That's a good question because that's something I've not said today, but you have to have the original will for probate. So you can't show up with a copy. And I have my clients initial each page to prevent someone from forging or changing the document. And I do that with my trust too. We sign initial each page so that way it could not be changed or altered. But there's really, yes, to answer your question, you're the one responsible for that, and you would want the executor to know where your originals are. I think keeping them in a lockbox at the bank, you can get into the bank for a will search. So if you're concerned about somebody messing with your documents, I would recommend putting them in a lockbox at the bank, and then only at your death could someone get in the lockbox to get those documents. And then just keeping your executor and your attorney informed about where those documents are. Okay, Ashley's question. If someone doesn't need a trust or prefers to just do a will, can they make their own will and get it notarized, or do they need a lawyer? Great question, Ashley. Do you know how us lawyers stay in business? People doing their own wills. So that's actually, I tell everyone, do not do your own will or do not use online wills because Tennessee has such strict statutory requirements as to a duly executed will. So you've got to have two witnesses. You've got to have an attestation clause. You've got to have an affidavit. We do it very formally in our offices, two witnesses and a notary. No one else is allowed to be in the room. I highly, highly advise against these online wills. Unfortunately, I've seen way too many situations where someone thought they were doing what they wanted and it didn't end up well for them because we see such nuanced situations day in and day out, and it's the practice of law. You're learning and seeing new things every day. And unfortunately, the internet wills and these quick wills, I mean, as you've seen on this call, there's just so many nuanced areas that I end up having when I have an internet will and it's messed up and we have to do an interpretation, that costs the client a whole lot more than if they just had an estate planning attorney, spend the money. Usually, if you get it done right the first time, you're going to have life changes and you may have to change it in the future. But for the most part, it's very much worth the investment to get it done right the first time. Okay, next question. I have a 17-year-old turning 18 and I want her to receive everything. I want her to use life insurance to pay off the home. Would I need to set up a trust or do I need a will and still have it pay out? So since she's only 18, if you were okay with her getting all of your assets at 18, then, maybe you could just do a will, leave everything to her. But, chances are you might want her to have some guardrails until she reaches a certain age. So I would suggest probably at least, especially all the stuff you mentioned, you've got a lot to handle there, bank accounts, retirement, insurance. I also, if I have adult beneficiaries, I don't love putting retirement accounts in the trust. So I normally say you could give the retirement accounts, and still put some of your other assets, your home equity, your insurance, your brokerage accounts, put those in trust for the beneficiary. But yet they would have this retirement account that they've got access to. So there's ways to protect them, but still give them access to some money. So you might want to consider setting up a trust for her, unless she's just really responsible. Next question. Did you share your email? I think Rachel did. Yes, you can get in through my website. Absolutely. And yes, so you guys have asked really good questions. And as you can tell, this is just a very nuanced area. And like I said at the beginning, regardless of your health, wealth, or age, everybody needs to, needs this up-to-date planning. It really is the best gift that you can give your family, to have up-to-date estate planning. Keep it in a safe place. Make sure your executor knows where it is. I always tell my clients, you don't have to tell your kids what your will says or what your trust says, but you can tell them, I have a will, I have a trust, this is where it's at. I see a lot of situations where someone passes away untimely and nobody knows where the document is. You might just want to tell them who your attorney is, where the documents are. It really is one of the greatest acts of love. No one wants to think about their passing, but like I said at the beginning, this is really just an act of financial wellness. And it's shocking and staggering to me that nearly 60% of Americans don't have up-to-date estate planning, because it is really catastrophic what can happen, especially if you have a blended family, especially if you have minor children. And especially, I think one of the things that I have seen the most is husband or wife has, a piece of property in their name, and husband and wife really intended to protect and provide for each other. And for whatever reason, it was only in husband's name or wife's name. And then now this husband or wife has to give the kids a portion of that property because it wasn't titled husband and wife and there wasn't a will. And that was supposed to be their retirement. So even just to protect your spouse, you need to make sure you have all your assets titled properly and have the will in place to protect each other. But Rachel, we've only got it looks like we've got about 8 minutes left. We want to be respectful of everyone's time. I have enjoyed this. These were really great questions. You're welcome to unmute and ask questions too, since we have about 8 minutes left. Feel free to put something in the chat box if you want to. I think we have another question in there. I know it would be different for each person and situation, but is there an average cost? Becky, that's a good question. So an average cost, I think all attorneys charge different prices. I like to tell my very basic, if you're coming in, we will include a trust for your kids. This does not include a Tennessee Community Property Trust. It doesn't include a TIST. It might not include a marital trust, but usually, we like to tell clients, just so they know what they're getting themselves into, you're not going to be over $2,000, just so you know what you're getting into. It is a good estimate. I think there's lots of different prices. I know Nashville can be a lot more. I think the Nashville people are realizing Rutherford County rates might be a little lower, so they're figuring that out. But that's a good question, and I would just encourage you to check with the estate planning attorney. My intake form goes over my pricing on the last page, but depending on the sophistication of the type of trust or the nuances and the complexities, the price can vary. Okay. With the community property trust, can assets be adequate? Yes, absolutely. Assets can be added later during your lifetime. Once you pass away, obviously the play there is after the first passing, that you get the step up after the first passing. So you would want all the assets put in there before the first spouse were to pass away. Good question. And then I think there was one right before that. What about a trust that names one child as the beneficiary? Let's say we have multiple children, or would it be better to detail for each child? Like I talked about in the beginning, if you have minor children, you want to set up a pot trust, meaning one trust until the youngest reaches a certain age. I'm not a fan of having multiple beneficiaries of a trust unless it's minor children, because if you have minor children, you don't want to be doing accountings or, having to set up 3 different EINs, 3 different tax returns for 3 different trusts. So normally you have one trust until the youngest child reaches a certain age. Once they're adults, I like there to be a clean break. You want to set your beneficiaries up for success. You don't want them litigating with each other. So that's why you want to have a clean break at a certain age. So to answer your question, I would not suggest having multiple beneficiaries of a trust unless they're minor children. You want there to be a clean break because you don't want one child who has a lot of medical needs or one child who maybe goes to for more advanced degrees to be resenting the other child because they're not spending the trust corpus and the other child is. So that's why you would want a clean break at a certain age. Okay, well, let's see. I got some.
I've got one from Carol Martucci that was asked in the Q&A link. Ashley, it says, what about establishing a college education trust to provide a specific benefit to descendants who are pursuing higher education?
So that I would say I don't have enough information to answer that question. Are you wanting to make a gift to the university? That's possible. I do have clients who make gifts to MTSU to set up scholarships. That's always a good option, depending on the amount that you're wanting to set up. If it's for a certain individual, yes, we can write the trust to benefit the individual for their education. So that would just be a trust where you tweak the terms to make it more geared towards education. But if this is more broadly, that it sounds like you're talking of more of some type of charitable trust that's setting up scholarships. That can get really nuanced and complicated. So depending on the type of trust you're wanting to create and the amount you're wanting to fund, if you're just wanting to say like $100,000 for anyone from Cannon County that goes to MTSU, that would be more effective going to the MTSU Foundation and then doing a gift agreement with the foundation. Lots of wonderful people over there that would love to help you, and you can narrow those terms and give it to the MTSU Foundation and still have your wishes outlined. So I'm not really sure exactly what you were asking, but I hope that answers the question enough to give you some food for thought how you want to handle that.
Well, Ashley, I just want to say thank you so much for doing this for us. You answered so many questions that I didn't even know I had. So this has been really great. I really appreciate it.
Thank you. I was honored to be here. And like I said, MTSU means so much to me. I would not be where I'm at in my career without the support of this university and the opportunities that I had here. So I'm very grateful to be here. And thank you, Rachel, and thank you, Courtney. You guys do a great job. And go Blue Raiders.
Yay! Well, and just segueing from that, I do hope everybody here will join us for our salute to veterans and armed forces on Saturday. We'll be out in the Grove around 11 a.m. with pre-game festivities in the Veterans Village that's sponsored by the Charlie and Hazel Daniels Veterans Center. Kickoff for the game is at 2 p.m. And we will be having a virtual trivia in December. It's backed by popular demand, so it'll be a holiday theme. We'll have tons of prizes and raffles and giveaways. It'll be an hour of fun starting at 7 p.m. on December 11th. If you're interested, just go to mtalumni.com for more information. I did mention this in the chat, but I'll be sending everyone who registered a link to this tomorrow along with Ashley's information. Ashley, again, thank you for being with us today. It is so appreciated. So I hope you have a wonderful afternoon.
Thank you. Thank you, Rachel.
Okay. Bye.